I got two words for you, and you're probably going to be hearing them quite a bit. Shadow docket. That's the one thing in common with the Supreme Court's latest controversial decisions, including the High Court's decision not to get involved in the Texas abortion case, but also the ruling that ended the eviction moratorium, the ruling that reinstated a Trump-era immigration policy for asylum seekers, federal executions, COVID-19 restrictions, voting rights, and many more, and that was just this year. All these controversial issues were decided by way of the so-called shadow docket. And now the House and Senate Judiciary Committees are going to investigate the Supreme Court. I know the term sounds sort of shady, but the truth is the shadow docket has been around since the formation of the Supreme Court. The shadow docket refers to the thousands of decisions the High Court hands down every single term that defy its normal procedures. The normal procedure is the merits docket, where the justices receive full briefings, hear oral arguments, and deliver lengthy signed opinions. Cases decided by way of the shadow docket lack that public deliberation and transparency. They often come as a result of a request for emergency relief, but the rulings themselves do not generally include information about how each justice voted or why the majority came to a certain conclusion, and often come in the middle of the night, hence shadow. Historically, the shadow docket was reserved for denials of uncontroversial petitions and mundane scenarios. But in recent years, the shadow docket has grown substantially, and the types of cases decided under it have also shifted. Most recently, the court has started resolving politically charged disputes using the shadow docket, and these rulings are creating new precedents for lower courts to follow. Now, I mentioned the House and Senate Judiciary Committee earlier. Those lawmakers want to hold a hearing about the use by the High Court of the shadow docket, but a date for those hearings has not been announced. Now, it's also worth noting a House subcommittee actually held a hearing about the court's shadow docket back in February of this year. No action came of that hearing. We could be getting some declassified September 11th government documents very soon, all because of an executive order the president signed a few days ago. This all comes as we move closer to the 20th anniversary of 9/11, and the president is continuing to face increasing pressure from survivors and families of victims. The president says Americans continue to seek full accountability for those horrific attacks and deserve to have a fuller picture of what their government knows about that day. So what are we getting? Well, no later than September 11th, 2021, we could get some declassified FBI communication documents from 2016 stemming from a lawsuit brought by the families of 9/11 victims. The president then ordered the Attorney General and other heads of departments within 120 days to complete declassification reviews of all interview reports, analytical documents, investigative findings, phone records, and possibly bank records from the FBI's initial investigation into the 9/11 attacks. Within 180 days, a declassified review must be completed for all records from any separate FBI investigation into any of the potential individual subjects connected to any agency relationship with a foreign government. When each declassification review is completed, the Attorney General is ordered to make that information publicly available. The president specifically said the indiscriminate release of classified information could jeopardize national security, and he's not going to do that. But he said certain information should not remain classified when the public interest outweighs any potential threat to national security.